I want to address the removal of the registration language, because as we all know, our statutes, 1147-41, make it strictly prohibited for the government to register firearms or firearm owners. And we have simply changed it from registration to a voluntary certificate of possession. In order for one to obtain such a certificate, one must bring that firearm's serial number, a model number. They must undergo a background check. They must provide fingerprints in order to obtain this certificate. And then the statute, this proposed bill, law will then states that the police department shall not keep any of that information. If they're not going to keep any of the information, why does that information need to be provided? And that's a rhetorical question. And furthermore, if we have to do that, and if we don't obtain this voluntary certificate, and we happen to be driving to our range, whether it's licensed or bona fide notwithstanding, and we are interacting with law enforcement, and we do not have a certificate, we are now felons. I don't think that's voluntary. I think that's a registry. That sounds involuntary to me, and that sounds like a registry with a different name. Again, more of a comment. Thank you.
A mischaracterization of the bill.
No, it's not. It's 100% factually accurate to the bill.
Through the chair, if we're making comments, that's a mischaracterization of the bill. A person does not have to do one single thing to remain legal under this bill.
If that person, through the chair, if that person is transporting that firearm to either a gunsmith or anywhere where it's deemed to be legal, and a police officer does a routine traffic stop, observes the firearm, asks them for their certificate, their voluntary certificate of possession, and they're unable to produce it, are they not subject to the penalties of this law?
No.
They're not.
No. Read
Okay.
it. No.
Okay. Excellent.